Community land trusts grew out of the civil rights movement in the U.S. The first community land trust was established 50 years ago, led by Slater King, cousin of Dr. Martin Luther King Jr. Douglas Community Land Trust builds on this legacy, the spirit of Frederick Douglass, and the work of more than 250 community land trusts in different regions throughout the country. Racial and economic justice center our mission. Douglas Community Land Trust is a membership organization. We invite you to join.
Thank you, everybody, for coming to our presentation tonight by the Equal Rights Center on reasonable accommodations and disability compliance. We are just, I will hand it off to one of our board members, Sylvia Salazar, in just a moment, but I want to note some housekeeping. As we've already, sorry, I realize I'm talking very quickly and I should slow down because we have interpretation happening. And if you have any questions, please throw them in the chat or raise your hand and we'll try and assist anybody who needs help into the Spanish channel. And we will try and help you out. We will be getting a we will be answering questions throughout the presentation, and please feel free to interact and raise your hand if you want to speak on anything or have any questions throughout the presentation. Feel free to throw other questions in the Q&A portion of the Zoom, and we will grab them at the end as well. Sylvia, please feel free to kick us off.
Alrighty. Welcome, everybody. My name is Sylvia Salazar, and I'm one of the board members at Douglas Community Land Trust. Bienvenidos a todos. And I'll allow for the interpretation.
Welcome.
And this is, we are lucky enough to have consecutive interpretation.
Is the interpretation simultaneous, or do I need to stop?
Sorry, yes, I'm sorry, simultaneous, not consecutive. Yes, simultaneous.
Okay, not consecutive. Okay. Well, let me give you some information about Douglas Community Land Trust. And we're basically a racial and economic equity membership organization. And, you know, as the past 2 years have been so interesting in terms of what's happening around racial equity. And we're so glad that we were already thinking ahead and doing organizing work around this ahead of time. And how we function is we're basically, we do our best to keep housing affordable in perpetuity, which means forever. And that includes providing stewardship services and technical assistance to cooperatives, housing cooperatives, which I happen to live in a housing cooperative, and as well as other resident associations. And stewardship is so important for cooperatives and housing associations because as you navigate the process of collectively owning a property, there's a lot of things to consider in managing the property, dealing with the issues that come up when you live in the housing and you own it collectively. There's challenges along the ways in terms of how to handle resources or even just conflicts of interest, those kinds of things. And stewardship, I can tell you from my cooperative, has been instrumental to ensuring that we're still standing here, especially when there's disagreements between members of an association or a cooperative. It's been really key for us. I can't speak highly enough about that. And I'd also like to thank our community partners. That would be Neighborhood Legal Services, Mi Casa, and LEDC, and housing counseling services. And most of all, want to give thank you to the Equal Rights Center for presenting today on this very important topic that has to do with how we meet the needs of people with disabilities. And it's something that we want to be able to do responsibly, and thankfully, thanks to the Equal Rights Center, we'll be able to have a better understanding about how to go about doing that. So at this point, I'm going to hand it off either to Adam or Brian from ERC.
All right. Hey, everybody. Good evening. My name is Brian McKenzie. I'm here representing the Equal Rights Center here today. Let me take down the previous screen share and pull up the PowerPoint here. All right. I think we should be good to go. Can I get a quick confirmation here from folks who are attending by raising your hand that you can hear me, you can see the PowerPoint? You can just raise your hand. Hopefully everything's working well. All right, great. So let's get rolling. So again, my name is Brian McKenzie. I am joining you today from the Equal Rights Center, where I am the Senior Training and Program Compliance Manager. That's just a long-winded way of saying that I talk a lot for a living. We have a whole lot of ground to cover here today. Without further ado, I do need to give one disclaimer here, though. I am not an attorney, so nothing you are hearing today should be considered legal advice. This will all be done in the frame of best practices. Okay, folks? So thank you again for having me here today. And we're going to run through all sorts of topics related to best practices for providing services to persons with disabilities. If you have any questions, feel free to ask questions again throughout the presentation today. I have the chat pulled up here and the Q&A. Either one works. Again, feel free to chime in whenever you want. Yeah, and there absolutely any question while you got me here, as Dinah says in the chat, there is a good question. So let's jump into it here. As I mentioned, I am joining you today from the Equal Rights Center. We are a civil rights organization located out of Washington, D.C. Our mission is that we identify and seek to eliminate unlawful and unfair discrimination in housing, employment, and public accommodations around DC, and we do nationwide work as well. Hey, I like to remind people when they attend these trainings, absolutely, you are here in a professional capacity. However, these laws that we're going to talk about, they protect every single one of us in many different aspects of your life. It is not just about compliance and about your professional work. These laws do apply to every single one of us as well. Okay, so let's just start with some fair housing basics, so we're all on the same page. We can define fair housing as the sale and the rental of housing free from discriminatory practices or policies, while continuing to treat everyone equally and with respect. So in the chat here or in the Q&A, let me ask, why are some reasons that I hope fair housing is important to everybody here today, regardless of your role? So in the chat or in the Q&A, why is fair housing important? I can think of a few different reasons. One is a pretty bottom line where, yeah, the Fair Housing Act is a law. That means we have to follow the law. If you break the law, there are consequences. So of course, fair housing is important. It's also the right thing to do. And fair housing, as Chantel says here in the chat, absolutely the right thing to do. Everybody has an opportunity to be treated fairly and equally, regardless of their protected class status. As Greg echoes that, to prevent discrimination, exactly. And hey, I always like to argue too, that it is a smart business practice as well. If you have a discriminatory policy or a discriminatory practice, word is going to get out. Trust me, I do this for a living. People are going to see it on Google, in Facebook, social media. We had a case around Instagram last year where an agent had posted discriminatory comments on Instagram. Well, social media is advertising, so word will get out. So fair housing is absolutely the right thing to do. It is, of course, civil rights law, and it is a smart business practice. By the way, here, I do encourage, again, folks to comment in the chat or in the Q&A. And I also like to, recognize when folks hear or respond to things. So if I do mispronounce your name, I apologize. I'm trying my best. Feel free to correct me in the chat. I will not be offended, but please accept my apologies. And I do see here, Adam, that there is an issue in the chat with accessing interpretation. I don't know if you want me to pause or continue.
Why don't you keep going, and we'll try to resolve this as quickly as we can. Thank you, Brian.
All right. Thank you very much, Adam. So the Fair Housing Act's overall goal is to, of course, make discrimination in housing illegal. You see that photo of Martin Luther King up there because it is also important to quickly recognize the history of the Fair Housing Act as well. The Fair Housing Act was signed into law, for those of you who are unfamiliar, on April 11th, 1968. That's exactly 1 week after the assassination of Dr. King in Memphis, Tennessee. It was passed, and that's not a coincidence at all, as a tribute to the legacy of Dr. King in support of the open housing movement going on at the time. But it was also a reaction, a political reaction. The Fair Housing Act had sat in Congress for 2 years until the assassination. And all of a sudden it's passed again as that tribute to Dr. King, but also as a reaction to protests, to demonstrations that were going on across the country during that period, during the immediate aftermath of the assassination. I'm originally from Pittsburgh. We have Freedom Corner in the Hill District where people met and marched in 1968. DC also was, of course, a notable center for demonstrations during that period as well. So that's how we got the Fair Housing Act again, 53 years ago. When we start to kind of drill into the law itself, we can look at this image of a wheel. I think is really useful. And it's made up of 3 big parts. So there's 3 things that we as housing providers need to follow: protected classes, prohibited activities, and our accessibility requirements. And the reason I like that wheel is because you really do need all 3 parts of the Fair Housing Act to be working together to keep the Fair Housing Act rolling. And I'll explain more about what I mean by that in a few minutes. But for example, protected classes, prohibited activities, they need to both be present and they both need to be represented when it comes to a fair housing case. And again, I'll share some examples of exactly what I mean by that here in just a minute or two. Okay, so then let's look at kind of the law itself. And I'm not going to read all that legalese up there on your screen, but just know the Fair Housing Act covers any building, structure, or portion that's designed or intended for occupancy, which of course means a variety of different things. For example, apartment buildings, housing cooperatives, condos, emergency shelters, transitional housing, single-family housing, college dorm rooms, mobile home parks, nursing homes, assisted living facilities, and then even vacant land designated for residential construction could be covered under the Fair Housing Act. So let me ask y'all here a trivia question to start off the night here. How could vacant land? That makes no sense. Vacant land, why would that ever be covered by something known as the Fair Housing Act? Nobody lives there. There's no house. Why would that ever be covered? Anybody want to throw anything into the chat there? And I do see Elizabeth has provided a tip in the chat about interpretation when they turn it on, in case that is helpful for anybody here. But why would vacant land ever be covered? Yeah, because see, people could live there. Exactly. Yeah. So you are ultimately, if you are discriminating against somebody who's attempting to purchase a plot of land, as Nicole says here in the chat, yeah, you're preventing them from living in a particular location. There are exemptions to the Fair Housing Act. I don't think we need to cover this super in depth here today. Just so people are aware though, you might see housing for people who are 65 and up or 55 and up. That's housing for older persons. They probably have qualified for an exemption. There are also religious exemptions to the Fair Housing Act as well. And then there are various small landlord exemptions too. So if you happen to own any properties in your private life, hey, the best rule of thumb I've got for you, make sure your advertising is in check. I cannot tell you how many small landlords, small housing providers we encounter who are exempt. They own maybe just one apartment unit. And then all of a sudden they make a bad ad on Craigslist and they have now forfeited their fair housing exemption. Advertising as a rule when it comes to compliance with the Fair Housing Act is absolutely something that you need to pay attention to. All right, great. I'm glad I see that happening in the chat there. Good. All right. So if nobody has any other questions around kind of the exemptions or the basics and introductions to fair housing, let's start moving through that wheel. And I think we'll ultimately see why all of these are important to discuss before we get to reasonable accommodations, because reasonable accommodations involve protected classes and they involve prohibited activities. So a reasonable accommodation is ultimately going to be a great example of how the Fair Housing Act really works again as that wheel. So a protected class, probably what the Fair Housing Act is most famous for. And we can start just with a real basic definition. A protected class can be thought of as a group of people who share a common trait or common characteristic and are then legally protected from discrimination because of a particular trait or characteristic. So there are 7 federal protections. We'll start with the big 7 because these are pretty well known, I think, a lot of the time. So let's see if we can get them all in the chat here. Hopefully people are familiar with these. What do y'all think are some examples of a federal protection? Again, these apply to everybody. If you happen to be joining me from Alaska today, these 7 protected classes will still apply. Anybody with any thoughts on what one of these protections might entail? A protected trait. Yeah, race, absolutely. Sex, absolutely. Nicole's on a roll there. Other examples. Religion, absolutely. National origin from Chantel. Greg chimes in with a bunch of them there. I think we're still missing 3 of them. One of them we're here to talk about for most of the time together today. How about disability? Yeah. And then we have family status and we have color as well. So our big 7 federal protections are going to be race, color, national origin, religion, sex, family status, and disability. So not going to go super in depth here into a few of these because I do want to make sure we get to reasonable accommodations, just to provide a few important best practices. National origin refers to where you and your family are from. Religion. Hey, as a best practice here, remember, all religions are equal under the FHA. If you go to the Department of Justice's website, there is no list of religions. Religion refers to all organized religions and the lack of religion as well. So as a best practice, remember, conversations around religion are tricky as a housing provider because religion is a protected class. Okay, folks? So sex discrimination actually has a pretty big significant update here as of 2021. And that is the umbrella of sex discrimination now includes claims of discrimination based off of sexual orientation and gender identity as well. So even though you don't see those 2 things listed on your screen, they are now protected at the federal level under the umbrella of sex discrimination. Okay. So we have some kind of a new expanded protections here in America under the Federal Fair Housing Act. So pretty cool under 2021. Then we have family status. That's a tricky one. Anybody want to throw out what they think family status might be referring to here in the chat or in the Q&A? What do you think? What could family status be? Is that going to be just a protection for somebody who's married with children? Yeah, it could be two moms. It cannot be somebody who's single. All right, we got a couple of good guesses here. So actually, yeah, the word family, I think, kind of throws people off here. It gets a little tricky. Family status actually has nothing to do with your parental structure. It's a family with children under the age of 18 and pregnancy. So a rule that targets children, saying no kids allowed, all of that is going to be under the umbrella of family status discrimination. And then, of course, we have disability, which we're going to be talking about a whole bunch here in just a couple of minutes. So let me ask here my follow-up question. Anybody have any thoughts or guesses on what is the #1 protected class in terms of a complaint filed across the country? Out of those 7, pick a jurisdiction. This one is always #1. Yeah, Chantel, disability, #1 in pretty much every jurisdiction nationwide. And why we're here today, we need to make sure we are all handling accommodation or modification requests in a fair and equitable manner, because again, disability is a really unique protected class, and that's why it gets so much time dedicated to it. I did just want to provide a couple of examples as sexual orientation and gender identity are now included under the umbrella of sex discrimination as of 2021. So an example of discrimination based off of sexual orientation might be refusing to rent to a same gender couple. And an example of discrimination based on gender identity could be harassing a tenant by not using correct pronouns or chosen name on purpose, especially in a hostile manner, or a landlord who charges different fees or different conditions after a tenant transitions. Okay, so good job with the big 7 protected classes there. But of course, it's not that easy because we do have additional protections here in Washington, D.C. D.C., hey, it's great. We have one big government body. Don't have to worry about individual towns, individual counties or states, but we have the biggest list of protected classes pretty much anywhere in the country. So again, as a reminder, it's always up to everybody to know what is protected in your local area. We will run through these quickly here today. All right, so here is the list of local protections. If this is brand new to you, please contact me. I'll send my email out earlier, but I will make sure that you have a list of all of these protections. They're on our website. I can make sure you have a list here if this is brand new information to you. But age is a protected class. So we see that one most likely through, frankly, advertising. A whole bunch of advertisements where we see rules, or not rules, that's sorry. We see ads geared towards young professionals, or ads geared for millennials, or we see ads targeting people over 40 on social media. So there we go. All of that, again, is going to be potentially age discrimination. Marital status. So single, married, divorced, widowed, whatever. Probably the most common way we see that one occur is with a landlord who has a 1-bedroom apartment for rent, and they say, hey, you need to be married to rent this apartment unit. All right, then we've talked about sexual orientation and gender identity already, so we'll kind of keep moving for now. The big one, source of income. Anybody with a guess in the chat about what source of income might refer to? What could we be talking about with source of income? Oh, Greg, all right, right away. Housing choice vouchers. Yeah, vouchers are a legal form of income in Washington, D.C. Chantel says employment, job income, absolutely. Alimony, child support, yeah. Any legal form of income can be considered when you're determining whether or not an applicant is qualified. I'm going to come back to that one in a little bit here because I do want to make sure we talk about vouchers for just a minute. But yeah, again, the good rule of thumb there, any legal form of income should be considered. Family responsibilities is essentially a caretaker law. So if somebody perhaps needs an extra key or an extra fob, a housing provider should be willing, to have an elderly, because they have an elderly relative. And so maybe they need somebody to look in after that elderly relative. That's a family responsibility. So you can kind of think of it again like a caretaker law. Of course, it's Washington, D.C. Political affiliation is going to be a protected class. So you can't take politics into account when you are interviewing folks for residency. Don't be asking about politics or anything like that. Personal appearance. That one you can think of as oftentimes there are stand-ins, or a word that we use in fair housing a lot is called a proxy. A proxy is kind of, again, like a stand-in or a representation. So sometimes you might have housing providers, or this is one of those where, remember, these laws apply to different aspects of life. I think this one probably is more focused towards employment and dress codes at work. So you think of a dress code or you think of a hairstyle, and disqualifying somebody because of a particular hairstyle or a particular style of dress, that could very easily be race discrimination or religious discrimination or national origin. Those are all associated with or have associations with particular styles of dress or particular hairstyles. Matriculation, fancy way, is just saying student status right there. Then we have protections for survivors of domestic violence. Really, the most common way we see that one is housing providers who disqualify a survivor because they're afraid of the ex coming back and damaging property or disrupting the community. In general, any rule that targets survivors for being a survivor is probably going to run afoul of that protected class protection. And then we have actually my favorite protected class. That's such a nerdy thing to say, I know, but I love maps. And place of residence or business. In Washington, D.C., and in a lot of other cities, it is super easy to make a well-educated guess about somebody's race or somebody's national origin simply by knowing their zip code or their address. DC, while it is one of the most diverse cities in the country, it's also one of the most segregated cities in the country still today. So if you are disqualifying somebody from a housing opportunity because they are applying from a zip code like 219 or something like that, well, you have now run afoul of the DC Human Rights Act because it is place of residence or business. I think that is actually a crucial protection in Washington, D.C., and probably underreported, to be honest. All right, I did want to take a couple of minutes here to come back to source of income. So when we talked about housing choice vouchers earlier, or any legal form of income, some common examples of source of income discrimination include against child support, alimony, rapid rehousing, veterans benefits, disability benefits, or housing choice vouchers. So again, commonly known as the Section 8 program. All of these are legal forms of income. I think really housing choice vouchers and rapid rehousing are really the, and I apologize, I'll try to slow down here a little bit. Thank you. Housing choice vouchers and rapid rehousing are really the two biggest examples of discrimination that we see when it comes to source of income. If you have any questions about those programs, we can speak maybe offline on that here about the specifics of those programs. But some common examples that we see might say no Section 8, no vouchers accepted, must be fully employed. Could anybody think of what other protected class might be covered by saying somebody must be fully employed? I think there's a federal protection here at play as well. How about disability benefits? Yeah, so somebody is off mute. Let me double check here. Thank you. All right, so yeah, disability benefits could be at play there as well. Again, any legal form of income when it comes to source of income. So this is a pretty hot topic in Washington, D.C. Does anybody have any questions around the Housing Choice Voucher Program or around rapid rehousing? I'll just pause and take a sip of my water here. All right. So if people are determining payment amounts based off of a voucher, it needs to be based on their portion of a rent or whatever amount they are paying, fees. So honestly, again, I don't think this is super applicable to all of you here tonight. So I think we can kind of jump through it. But again, the key thing there to consider is it's based on your or the applicant's portion of the rent. So if you ever are running income checks or income qualifications, it's based on their portion. The voucher amount is a fully guaranteed amount. So it's going to be automatically direct deposit to the housing provider. So again, always based on their portion of the rent and anybody who uses an income qualification. All right, another thing I want to quickly touch on here is criminal background checks. So especially when you are interviewing prospects or interacting with prospects or potential residents, keep in mind, DC has really specific guidelines for when it is okay to ask about criminal backgrounds. And also guidelines for what can be asked about criminal backgrounds. So for example, in Washington, D.C., we have a 7-year look back window. So that means crimes that have been convicted for in the last 7 years could be considered. You have to provide guidelines for eligibility for what is to be considered for applicants with their criminal background. You're not supposed to be inquiring about questions or an applicant's criminal background or arrest history prior to making a conditional offer. So again, you don't want to be asking about somebody's criminal background during the interview process. And another important step is allowing the applicant to correct false or inaccurate information after that is, or after they have had their background check run. So if you use background checks or you're using a criminal records check, please be aware that there are really, really pointed criteria in Washington, D.C. And I think the big one here for all of you too is keeping in mind about asking questions related to criminal background during the interview process. Okay, so now we're going to move quickly here into the second part of our wheel, which is going to be on prohibited activities. Essentially, these are things that you cannot do to somebody or say to somebody because of their protected class status. So let's start with the refusal to rent or the refusal to sell. I don't want you to live here because of your protected class status. Somebody can refuse to sell or refuse to rent to somebody because they've failed a background check or they have a poor rental history. It becomes a fair housing case when you refuse to sell or you refuse to rent to somebody because they have kids or because they have a voucher or because of their source of income. All right, the next one up there is enforcing or offering discriminatory terms or discriminatory conditions. This one is really easy to think about in rental terms. You change a term or condition, a deposit maybe, if anybody requires a deposit, and hey, you need to pay a 2-month deposit because you have kids. Again, you change the condition of purchase or you change the condition of a rental because of somebody's protected class status. Misrepresenting availability. Tell folks what's available, let them make their own decisions. Simple as that. We actually had a case around this one last year where we had a client who was moving here from the Bahamas. So she spoke with an accent. She contacted a property owner who told her that she would have to contact the property manager for a tour. They ended the phone call and our client received a text message that said, quote unquote, "She sounds African, give her the wrong address." So the property owner thought he was being smart and instructing the property manager to misrepresent availability and lie to our client. Only he texted our client, who took screenshots and contacted our agency. So misrepresenting availability. Tell folks what's available, let them make their own decisions. Then we have blockbusting or steering. These are some pretty big concepts that I'll just boil down into a quick little nutshell here. With blockbusting, you might have heard of a phrase, a panic sale or white flight. It's terms that are primarily related to encouraging white families to sell their properties because of the fear of the other, a fear of who's moving into the neighborhood and who's going to damage their property values. With steering, it's directing somebody to live in a particular location because of their protected class status. So it could be directing somebody to live in a neighborhood because of their national origin or their race or their religion. We had a guy who used to quote the census when he would take prospects to particular neighborhoods and say, you want to live here because this neighborhood is X percentage white or X percentage black. It can also be related to family status. Maybe it's putting all families with children on the first floor of a building because nobody likes families with kids running around on their ceiling. And then also we see this with disability as well. Then we have harassment, threats, intimidation, or coercion. I think that one is pretty self-explanatory. Retaliation. So if somebody files a fair housing complaint against you, please do not take any sort of punitive action against that person. Advertising, as I have touched on already, going to reinforce that one over and over again. And then, of course, the refusal to make reasonable accommodations or modifications, which we'll be talking about here for the remainder of our time together. So let's dive now into reasonable accommodations and modifications. Well, let me ask first, any questions on protected classes or prohibited activities before we kind of leave that behind for now? Okay, well, always feel free to submit that into the chat there. So let's start again with a few basic definitions that are going to help guide our interactions with people with disabilities. And we'll start with a real basic definition of disability. You can think of a disability as a physical or a mental impairment which substantially limits one or more of life's major activities. It can be a record of having such an impairment, or simply being regarded as having that impairment. So I think there are a couple of important things at play there, especially that last bullet point, being regarded as having an impairment. We're going to talk a lot about assumptions here today, and also disabilities that are not visible. The important thing to remember is that all disabilities are protected, though, under the Fair Housing Act. There are a few different types of disabilities. I do want to note here, these are just examples. This list is not exhaustive. We are just all developing a working understanding of disability. So this is not an exhaustive list. These are not mutually exclusive. Disabilities can fall into more than one category. But again, all disabilities are equal under the law. So we have mobility disabilities, somebody who uses an assistive device, wheelchairs, crutches, etc. Developmental disabilities occur before the age of 18, somebody who might be living with autism, for example. Intellectual or learning disabilities, ADHD, dyslexia, those are great examples there. Mental health disabilities, somebody who is living with depression, somebody who is bipolar, PTSD, etc. Sensory disabilities, somebody who is blind, somebody who is deaf. And then also we have hidden or invisible disabilities as well. Oftentimes I talked about how these can fall into more than one category. So somebody who is depressed or has depression could also have an invisible disability. Again, the category doesn't matter so much. Other invisible disabilities that we haven't talked about, somebody who is recovering from an illegal drug addiction, but not currently using, or somebody who's living with HIV/AIDS as well. So all of those factor into somebody who could have a disability. And again, many different types of disability that are protected under the law. We also have to consider, and I think a good rule of thumb here to keep in mind, is thinking about disability etiquette. Disability etiquette are essentially rules that guide how you can interact with a person with a disability in a fair way where you're focused on that person as a person and not as their disability. So some examples of disability etiquette. You want to ask before you help. You want to be sensitive about physical contact. You always want to speak directly to a person with a disability and not to their companion or to their interpreter. I'll share some examples of that actually in a couple of videos here later on, but you're speaking to the person. You want to think before you speak. You never want to make assumptions about somebody's disability. There's that word assumption. We're going to talk about assumptions a lot coming up here. And we want to respond graciously to any requests that are made. So again, this is disability etiquette. There are also different examples of disability etiquette to go along with different types of disabilities. Many of these are, I would almost call them common sense, but you're interacting or treating a person with respect and trying to communicate and interact with those folks in a manner with which they prefer. For example, for a person with a mobility impairment, you don't want to grab their wheelchair, their scooter, or their cane. That's an extension of their body. Please don't grab a person's arms, even if you think they're off balance. People use their arms for balance. Also, stay within the line of sight. So if a person in a wheelchair can't see over a counter, for example, you go around the counter and interact with that person. Simple as that. See, it's a lot of, I think, really common sense behaviors. For people who are blind, again, people who are blind use their arms for balance. So you want to offer your arm. You don't want to be grabbing that person's arm. Again, don't touch a person's cane or their guide dog. It's an extension of their body or a working animal. You want to offer to read written information. When assisting somebody who's blind, explain where items are at located by using a clock as a framework. So in the chat here, if I ask you, where is your computer right now? If you were using that clock, what would you say if it's right in front of you? Something that's in front of you is at 12 o'clock. Exactly. Yep. So again, remember that clock as a framework. 6 o'clock would be behind the person. For people who are deaf or have hearing loss, you want to follow that person's cues to figure out how they prefer to communicate, whether through sign language, gesturing, writing, or speaking. And keep in mind that people who are deaf make and receive telephone calls using a variety of different services. I'm going to talk more about that as a best practice here in a little bit. So we can leave that one there, I think, for now. For people with disabilities that impact their speech, again, you're going to notice some common themes here. Give that person enough time to articulate their thoughts. You don't want to interrupt or finish a person's sentences for them. If you have trouble understanding, ask them to repeat. If you cannot understand that person, even after asking them to repeat, how about suggesting another way to facilitate communication? It could be writing or typing out a conversation. Consider alternatives, but again, try to communicate in a manner that that person prefers. For people with intellectual or learning disabilities, please ask a person again how they can best receive that information, whether it's written, verbal, or a combination. Allow extra time for reading and offer to give verbal explanations of written material. Again, a common rule of thumb here that's going through all of these, hey, focus on how we can best communicate or how we can best interact with that person in a manner that they prefer. Okay, so now we're going to talk about reasonable accommodations and reasonable modifications. Both of these are going to be changes that give a person with a disability full use and enjoyment in their housing. A reasonable accommodation, we are just changing, as you see on your screen there, a rule, a policy, a practice, or a service. It is nothing physical, okay? These are normally done at the expense of the housing provider. Again, you're just changing a rule, you're just changing a policy. So some really well-known examples of accommodations might be allowing that assistance animal in a no pets building, waiving late fees for somebody who has a disability and their benefits arrive after a particular date, or offering interpretation or translation services. Does anybody have any other suggestions for what an accommodation might be? What other rules might you change for somebody with a disability or a policy? There's one big one that's not up there yet. All right. Oh, yeah. Lauren comes in with giving a caretaker. Yeah, allowing that live-in caretaker or that aide to stay, even if they're not on a lease. Absolutely. Yeah, that's an accommodation. The one that came to mind that wasn't up there that I thought of was parking. Allowing a reserved accessible spot is going to be an accommodation as well. And then we have our modifications, which Rachel and Chantel mentioned here, which are going to be our physical alterations. So structural changes made to units. These are generally done at the housing, at the residence expense. But again, it could be lowering countertops, building ramps, grab bars. The key here is that residents have a right to make modification requests to public use or common areas as well. So if you have a community room or you have shared space, residents still do have a right to make modification requests to those areas. Again, it could be grab bars, that's a common one. Ramps, another common one as well. And I have a comment in the chat here. Yeah, that's a great example of, again, another, we encounter this one actually a lot too, Lauren, allowing a resident to move to the ground level of a building when they can no longer use the stairs. Yeah, that's a really common accommodation request that we encounter as well. Many intakes around that one. So let's now talk about some policies and procedures as they relate to handling these accommodation or modification requests. So I work for the Equal Rights Center. I'm not familiar with all of your processes at all, but keep in mind, you may have forms, and that's great. Everybody loves forms, but residents can make these requests in writing or verbally. You should not be automatically rejecting or denying somebody's request because they are unwilling or unable to fill your form out. It also doesn't matter what disability somebody has. All you should be concerned with is their disability related to their request? It does not matter what disability somebody has under the law. Requests should be addressed in a timely manner. There is no firm guidelines given to what is considered to be a timely manner. I would just say, as a best practice here, if you are delaying these responses, document. Make sure you document any reason that you are delaying these requests. There is not, again, HUD doesn't give us and say, hey, you need to have these done in 24 hours. But if you are documenting, if you're delaying, hey, have a reason why. Document, make sure you have that shared, especially if it's perhaps, again, if it's going on for a while. I've heard some really horror stories where these requests go on for months and months. We have a question in the chat here. Is it against the law to inquire about proof of disability, not the details of disability? That's an excellent question. That's going to be about verification of a disability. And we're going to talk a lot about that coming up, I promise. So pocket that for now. We're going to get to it in just a slide or two. You always want to review each request on a case-by-case basis. So you don't have a firm rule that says, hey, we're rejecting any assistance animal request, for example. You have a case-by-case basis. Always respect people's privacy when it comes to their disability. When you're talking to other community members, again, you don't want to be discussing somebody's disability with any third parties. You are being respectful of people's privacy. Also, keep in mind, hey, residents may not have ever heard of a reasonable accommodation or a modification. If they are making a request, they don't need to use those terms. So please recognize when these requests are being made. Hacienda, I do see your question here. I'm going to save that one for the end because I'm going to want Adam to chime in on that one. So we're going to come back to that one at the end. But thank you for the question. So verification here, as Stanetta asked in the chat here. So how can we verify somebody's request? Well, right away, the first thing I'm going to say is that housing providers should only be verifying non-obvious disabilities. So again, there is no really clear definitions presented by this. It's kind of common sense. For example, if somebody is blind and they have a seeing eye dog, should you have to ask them to verify their disability? That is an obvious disability, for example. If it's a non-obvious disability, again, please, there is no need to verify that disability. Again, individuals can submit their requests in writing or verbally. Housing providers cannot reject a request from somebody who's unable or unwilling to fill their form out. Disabilities can be verified by third party with knowledge of a disability or a medical professional. So with regards to Stanetta's question about proof, all you are verifying is that their request is related to their disability. You're not verifying what disability an individual has. All that matters, again, is that the request is related to the disability. Rachel asks, excellent question again here. Who is a third party? So this is one of those fun areas as well, where HUD defines it as a third party with knowledge of a disability, and then gives some, really common sense examples like case managers, a psychologist, a therapist. It could be an AA sponsor, something like that. There are, though, other third parties as well. I think of the one third party that comes up a lot, and I'll mention this again later on, is, well, what about online documentation and assistance animals? What if somebody just prints out a certificate that they purchased online? Well, HUD says that that is no longer an acceptable third party unless it is by a licensed medical professional. I do think the big takeaway there is remembering it does not need to be a doctor's note. Other people can verify a disability. Self-verification up there means it's verification that is done through maybe a government document that says something about their disability, or a copy of their disability benefits if their request is related to their disability benefits. Again, all of this is handled on a really, really case-by-case basis. So it's important not to get kind of stuck in who exactly is or is not a third party, because again, there could be a situation where something is a third party or somebody is not a third party. Okay, so let's do a practice scenario here. An applicant who is blind requests that a policy document be read to them verbally. Should this request be granted, and should it require verification? And in the chat, what do folks think here? Should be granted. What about the verification, though? Do you want to say bring a doctor's note? I'm going to agree with, let me review folks' responses here, even though I think Lauren is a ringer because she works in housing. But I'm going to agree with Lauren here, who says, yeah, it should be granted without verification. As Rachel says, Chantel says, Gianna, Stanetta, yeah. No, Greg, we're talking about verifying that somebody has, that this is a disability. There's no need to verify. It is an obvious disability. We've got a question here about verification needed to smoke medical marijuana for PTSD or any other anxiety disorders. And unfortunately for this conversation with marijuana, I'm going to have to punt on that one because the guidance, frankly, is not clear for fair housing agencies like ourselves. This is something that is very, very in limbo because marijuana is not legal at the federal level. And so fair housing is a federal law. So this is a really murky right now topic for fair housing agencies like mine. So I'm going to have to punt on that one because we just kind of don't answer that question yet because we don't have any clear guidance on our end of things. But it comes up. It comes up all the time. It absolutely comes up, and we just don't. We just don't have right now, unfortunately, as a fair housing agency, with it still being illegal at the federal level. we don't have clear guidance on that one, frankly. But yeah, I agree with everybody there about saying it is a valid accommodation request. So some additional verification tips here. All we care about here when it comes to this process is remembering that it's a description of the needed accommodation or modification, and is it related to a disability? So if the answer to both of those questions is yes, if it's a description and if it's a demonstrated relationship, then yes, that accommodation should probably be granted. So again, all you care about a description and is this related to a disability? All right, our next scenario here. A resident with a mobility disability requests a reserved accessible parking spot in a lot with no accessible parking. Should the housing provider consider this request? What do you think here? Any thoughts on parking in this scenario? So for this one, yeah, so actually, and this one would not have to be. Now, again, the disability needs to be related to their request. So if somebody would have perhaps a different type of disability other than a mobility disability, maybe there isn't a relation. Again, you need to have a request that overlaps with the disability. A mobility disability certainly is related to parking and having that accessible access. So if there is parking at all being offered, frankly, this one is probably going to be ending up to be considered, or should at least be considered, and if not approved outright, unless the housing provider can say, hey, this is going to cost too much money, or this is going to be too dramatic of a change to our entire situation. But the burden would shift to the housing provider to be able to show that there. I think, again, this is going to be a request that a resident certainly has a right to make. Again, a good way of thinking about this, hey, folks, is when we assess these requests, if a disability overlaps with a request, approve that request. All right, so I did want to cover quickly here some information for video and IP relay services. We've been doing a lot of work with this field in the last year, providing services to individuals who are deaf or hard of hearing. And I think, especially with the pandemic ongoing, people are relying on these devices as they stay at home. So it's important for you all to be ready to go to handle any kinds of conversation that might come in, or an interview that comes in through one of these services. So we're going to take 3 minutes here and just look at a couple of different examples of what I mean by these services. So what these might look like. So stick with me. I'm going to bring down the screen share here for just a second. And we're going to bring up a quick video here, a couple quick videos. So there's going to be about a minute each here. Let me make sure I have my share settings. So the first one you're going to see is going to be called a video relay. Okay. So this is going to be a video relay. And the cool thing about this is actually it's going to be related to disability, but it's also going to be providing Spanish interpretation as well. So I think I have my screen share up. And again, we're just going to see a minute of this just to see exactly what a video relay service looks like. Let me make sure I have my share settings good. Okay. Oh, is my audio, something went on with my audio here, folks. Oh, there it is.
Bueno,
Hola, soy intérprete 123 y
perdón,
yo voy a...
perdón, disculpe, ¿quién dice que habla?
Soy intérprete 123 y tengo al señor Roberto en la línea. Él desea hablar con su tía Flor. ¿Se encuentra?
Sí, con ella. Oh, mi sobrino Roberto.
So there was no volume at the beginning because it was a conversation between two people who were using sign language, by the way. So that is a video relay service. So you see the individual is connected with the interpreter, and then they communicated through the interpreter with his aunt. So that's a video relay. So that involves video cameras. So technology, so newer technology. Our next example here is an IP relay. So this is going to be done through essentially a mobile device. This was the best example I could find. So I apologize that it's kind of a Sprint ad, but it's the best example going here. So again, let me just share this first example of what an IP relay looks like.
Never miss a word. You can use the phone virtually anytime, anywhere with Sprint IP Relay. Sprint IP Relay Mobile is an app for people who are deaf, deafblind, hard of hearing, or have a speech disability. An operator helps to create clear communication between you and the person you call. Sprint IP offers multiple products, apps, and services that allow you to communicate from home, at work, or on the go. Sprint IP makes communicating easier than ever using an internet connection, a computer, or mobile device. Type what you want to say and the operator relays your message to the caller and types their response back to you. It's easy to use and you can talk for as long as you'd like. Plus, there's no charge for long-distance calls in the U.S. or U.S. territories. Stay in touch 24/7.
All right, so I'm going to stop that before we get too much into the commercial there. So that's an IP relay. So you're communicating through a mobile app. And then kind of the old-fashioned way is through these video or these TTY calls, who some of these may be familiar with. So again, this is a little similar to IP relay. And these calls can be a little disorienting sometimes, especially if you've never fielded one. So again, we're just going to watch the first video here just to see what it looks like. And I'm glad you're enjoying the video.
A person who is deaf or hard of hearing may benefit from using a text telephone, also known as a TTY, to type his or her conversation. The operator then relays the other person's spoken words by typing them to the TTY user.
Travel time, this is Mary. May I help you?
Hello, person's calling through the relay service. This is relay operator 3600. Have you received a relay call before?
No, I don't think so.
The person who has called you is deaf or hard of hearing. The caller will type their conversation and I'll read it to you. When you hear the words, "Go ahead," it's your turn to speak, and I'll type everything heard. Please speak directly to the caller and say, "Go ahead," when you're ready for a response. One moment for your call to begin.
All right, so there you go. So again, you're speaking through the interpreter there. All right, let me bring back up the PowerPoint here. So hopefully that helps folks out if you've never encountered one of those calls. We did a series of investigations last year and really had pretty troubling results where hearing testers were told more information about units, fees, or rents. Deaf testers were hung up on multiple times or told they had to email an agent, or flat out told that the agent would not communicate through an interpreter. So really pretty troubling results when it came to this investigation. So I do encourage you to be familiar with those technologies and be ready to handle any calls that come in through those different types of technologies. So I do want to take a few minutes here to address assistance animals and housing, the fun topic of assistance animals. hey, keep in mind, under the Fair Housing Act, it does not matter if somebody says to you, I have a service dog, a comfort dog, a companion animal, an emotional support animal, a guide dog, a service animal. Again, all of these are okay under the FHA, the Fair Housing Act. It does not matter. Now, a service animal and an emotional support animal are different, but again, they are both allowed under the Fair Housing Act. So what does that mean for housing providers? That means that you need to treat these animals equally. No formal training can be required. No certificate can be required. There can be no special harness or a special vest that can be required. They can be any breed or any size. So that assistance animal that happens to be a pit bull, or that assistance animal that is 100 pounds, that's okay. Breed restrictions, weight restrictions do not apply. Residents can have more than one assistance animal. The rule of thumb there, if it is an disability related need for each animal, or if there are multiple members of a household that require an animal. And they don't have to be dogs. An assistance animal could be a cat. The rule of thumb there, it is an animal that is commonly domesticated and kept in the household. The best rule of thumb I can give you, remember, assistance animals are not pets. So just get that P word out of your head as soon as we start talking about assistance animals. So for example, a prospect says that they have a pit bull that is an emotional support animal. They ask an agent in a no pets building about their emotional support animal. What do y'all think? Should that pit bull be allowed in the building, a no pets building? I'm going to agree with Greg for sure. Gianna for sure. Hey, remember folks, I've got a couple no replies there. Hey, keep in mind, an assistance animal is not a pet. An emotional support animal is protected under the law. That means that that pit bull is an emotional support animal if it's verified, and it should be allowed in the no pets building. Okay, folks? Again, they can be any breed or they can be any size. An assistance animal is not a pet. Yep, Chantel, a pit bull can be an assistance animal. Breed restrictions do not apply. Both parties do have responsibilities. Yeah, I'm gonna plan on wrapping it in about 3 minutes. So property owners should not charge additional pet fees, pet deposits. And I see we have good questions here. I'm just going to get through these and then we're going to come back to the questions, folks, on assistance animals. Property managers should not charge additional pet fees, pet deposits, increased pet rent, additional security deposits. Allergies, fears of dogs are not valid reasons to deny an assistance animal for any community. Remember, disabilities may not be visible, in which case you may verify that the requester has a disability. It does not matter what disability is present. Again, all you care about is if the disability is related to the request. And I do see a question from Hacienda here. And I think this is the next scenario, so we'll keep this one and then scratch the last one. But a resident in a no pets building inquires why a fellow resident is allowed a dog, but they are not. How should the board member reply? So, and this is just the example that came up. This is a tricky one. Hey, I hear it. Yeah, this is a really, really tricky one. But you need to remember a couple of things here as best practices. First, a person has a right to make that request, and a person has a right to that assistance animal as a reasonable accommodation. Now, you need to respect that other resident's privacy as much as possible. So what I would do here and what I would encourage you to do is to say something along the lines of, we allow assistance animals for a variety of different reasons. If you would like to make a request, we can talk more about that process, but you want to encourage them and say, hey, you can make that request, but you are respecting the individual's privacy and certainly not sharing information about their disability. That's a great question. And that's a tough one that does come up a lot. And you need to balance out members' privacy while also encouraging that person. They may have their disability. They may be attempting to make a request. So also do encourage that person to make a request if possible. Owner's responsibilities. The animal should not pose a threat to the other residents or to property. However, because you're a particular breed, does not make you a threat. So we come back to that topic of pit bulls. Residents should still follow common pet rules, leash usage, cleanup, general control of the animal. And residents are still financially responsible for any property damage done in rentals, but it would come out of a pet deposit and not, I'm sorry, out of the security deposit and not necessarily the pet deposit. And then folks, if this is a topic that is of more interest to you, I am going to share a link in the chat here to a video that we put together that handles all of these really basic questions that do come up. So I'll share that in the chat before we conclude today here. Let me just see where I'm at. I think we are, yeah, at the end here. So I'm just going to scrap that last scenario and transition here back to Adam while I share our video link in the chat here.
All right, thank you, Brian. Let me see this real quick. Yep, so thank you again. We are going to move on to Q&A very, very shortly. So we are going to have questions and answers in just a moment. So please send them into the chat. But right now we're going to hear from a couple of our community partners who are providing very important work to provide technical assistance to each of your co-ops and other types of organizations. We're going to start out with Elizabeth from Neighborhood Legal Services Program.
Hi, everyone. It's great to see such robust participation in this training. I am our supervising attorney at Neighborhood Legal Services Program's Housing Cooperative Preservation Initiative. So very much appreciate DCLT and all of the other sponsors for organizing this wonderful training. Just a brief word on what we do. We provide legal services to cooperatives, to housing cooperatives. We work as what we like to call limited general counsel. So what that means is for the co-ops that we work with long-term, any sort of legal question that you have, we try to help sort of triage and help you find an answer to that question. So there's a lot of stuff that we can do in-house with our own staff resources. For things that we can't handle in-house, we are often able to find other private attorneys who work pro bono for free to provide additional services to the cooperatives that we work with. And then we also work with University Legal Services to provide some additional asset management services to cooperatives that aren't already receiving that assistance from folks. And what asset management generally is things more on the financial side, financial questions, sort of building renovation questions, things like that. But we do work with co-ops that already have that assistance and just need the legal piece as well. So I will leave, I believe our contact information is not on the slide. I will leave my contact information in the chat for anyone who might be interested in following up with us about our services.
Excellent, thank you, Elizabeth. Now our friends at Casa, is it Zalella?
Hello. I am Dalalam from Mikasa. I hope everybody knows that Mikasa has been in the city for over 28 years, serving the low and moderate income community as housing development consultant. I'm currently, working as a technical assistant and training coordinator at Casa. We are providing variety of assistance. We have three major areas, just to point out. The first one is we provide development consultant, mostly for limited equity cooperatives. And we also own, some properties that Casa owns. When residents give, their TOPA right, they pass their TOPA right to Casa. So we have a number of properties that we provide service, and they are rental properties. We also provide technical assistance for post-development projects, as well as training services. As you can see, our next training is offered on December 9th on asset management. We are planning to provide this training to board of directors of limited equity cooperatives. Please pass the word, if you are connected with cooperatives, and even to members. It will be very helpful training, and I look forward, to partner with all of you going forward.
Great, and you might hear some familiar voices and faces on that next training, and I think perhaps as early as tomorrow we will be partnered with Casa on a property. So love working with them. Thank you, Zelalem, for coming tonight.
Thank you.
LT.
Hi, all. Good evening. My name is Lauren Taylor. I'm a tenant organizer and manager of the Affordable Housing Preservation Program at the Latino Economic Development Center. We're a large nonprofit based in DC, but also with offices in Maryland, Virginia, and Puerto Rico. And as tenant organizers, we've had the great privilege of accompanying a number of tenant associations who have decided to convert to cooperative associations and gone through the TOPA process, gone through a building sale, and supported folks in organizing to build a co-op. We often rely on community partners like Casa and NLSP and the Douglas Community Land Trust to provide some more of the technical expertise. But we're really excited to support people in coming together and training and working together to make this happen. In addition to supporting co-ops, we also support tenants around fighting for better conditions and making decisions about what's best for tenants when the building's for sale. We have other programs as well that support folks in starting or sustaining small businesses, in purchasing their own homes or staying in their own home. We also have rental assistance support, and some of that rental assistance does apply to cooperative members as well. So we were a part of assisting people in applying for Stay DC and a previous rental assistance program called tenant-based rental assistance, and hope to continue to do that work. And yeah, we're really excited to be on here with you all and learning with you all as well.
Excellent, thank you, LP. Okay, guys, we are coming right up at the time. Brian, could you address this this question by Hacienda?
Yeah,
if
sure.
a resident who has a mental disability requests a ground apartment or apartment where washers and dryers are granted for fear of falling due to side effects of medication, dizziness, etc., when they have a verification.
Yeah, I think this is a very valid, reasonable accommodation request. I'm going to preface, I guess, not preface because I just said it, but should say this sounds really specific. So if this is a specific situation, I do need to remind you, not an attorney, so not legal advice. However, I would say that, yeah, this sounds like, on the surface, a pretty clear, reasonable accommodation. The resident has a disability, and the request sounds like it is related to their disability. And it sounds like they probably have very easy access to verification if necessary. Or it sounds like they already have verification, perhaps if they have the side effects listed of their medication as well. So yeah, I think that's a pretty clear accommodation.
And I guess Nicole is maybe asking, and Nicole, correct me if I'm wrong, what happens when a tenant has a member of the family joined them who has a disability?
Sure. Yeah. So, hey, when that relative, that relative with a disability moves in, they are protected under the Fair Housing Act, and they have a right to modification requests. I would remind you, however, in that particular situation, that oftentimes, and I'm going to again kind of say, depending on funding, because there are situations where housing providers are responsible for the cost of the modification. In general, though, a resident is responsible for the cost of a modification. So certainly the relative can move in, and the relative has a right to modification requests at the expense of the resident.
Great. So I feel like we could have just covered so many other questions, but I want to wrap it, or at least officially wrap it, right on time, and respect everybody's time. We've really appreciated having everybody participate. At the Douglas Community Land Trust, we try and put on a training with our partners on a regular basis. And right now we have a couple of events coming up, mostly for, as Sylvia mentioned, we are a membership organization. We are guided and directed by our members with a board that is made up of that membership. So we are not a self-perpetuating board. So we have a new and prospective member orientation coming up December 1st. And then our, I think it's our second annual members meeting on December 15th. And that is going to be specifically for members. So if you all are interested in joining, we have an open membership to people who live, work, or have another affiliation to DC. So please feel free to join us. And I want to make a big thanks for our interpreters who have been phenomenal, both doing technical assistance as well as providing ongoing, of course, interpretation throughout the presentation. And we are happy to work with YNS. So once again, we're going to circulate all this information, the contact information for everybody that spoke tonight, as well as all the written material and hopefully the video as well very soon. So thank you, everybody, and we are going to close it out. And feel free, if you have questions that didn't get answered, send them to myself or one of our, myself and I will direct them to one of our partners. Thank you and have a terrific night. I'm gonna stick around just to make sure I get all the questions from the chat. I'm still here, but thank you to everybody. Thank you to our partners for coming out, and please come out for our next one.